form and then comment before you can, so that they can be finalized. So this is a communique of the high-level Legal, Constitutional and Affairs and Intergovernmental Relations Committee of COG and the County Attorney's meeting held on 24th and 25th February 2022. The Council of Governors convened a two-day high-level consultative forum defining the devolution agenda 2022 and beyond. And it was at this hotel, the Three Stairs Hotel in Meru County. The forum brought together representatives of the Legal and Constitutional Affairs and Intergovernmental Relations Committee of COG, the county attorneys, the Senate, the National Assembly, and the County Assemblies Forum. The forum interrogated the institutional, policy, and legislative barriers that hinder effective implementation of devolution, with a view to coming up with strategies to address the challenges and ensure that devolution works better and well. In line with the objectives set for the meeting, and in recognition that devolution is a powerful tool for socioeconomic transformation and enhancing grassroots democracy, the devolution family has agreed as follows. Number one, that all institutions in the devolution family will continue to work harmoniously together to ensure service delivery to all the people of Kenya. Number two, the institutions present have agreed to jointly come up with a framework for oversight which clearly delineates the roles and responsibilities of the Senate and the county assemblies. Number three, the devolution family has agreed that all efforts shall be made in developing and reviewing key policy and legislation on exclusive and concurrent functions, including those under the health, agriculture, water, and road sectors. As the principal legal advisors to the county governments, especially as we go into a position of transition, the devolution family identified certain areas that will strengthen devolution and enhance delivery of services to the people of Kenya at the county levels. We are privileged to be the very first person, to be the very first presidential candidate to be aware of our 11-point reducible minimum devolution agenda, because we have said first, we shall support the candidate on the basis of their support for this reducible minimum agenda. All the models proposed by hopeful candidates, devolution offers the best vehicle for realization of these aspirations. The following priority areas, which we launched today: devolution minimum. We avoid to ensure reforms in the health sector, including restructuring and decentralization of KEMSA and NHIF, to align them to the devolved system of government and ensure mechanisms for adequate accountability of financial resources, health products, and technologies. So these ones, KEMSA and NHIF, should be restructured and decentralized to align them to the legal demands of devolution. 4, you have proposed that a high-level committee be established and empowered to undertake comprehensive review of all policies and legislation to align them to the Constitution and the devolved system of government. The committee will also monitor and be compliant with existing laws. For this, we have proposed that the Rural Reform Commission be restructured to include representation from county governments, and it's that consistent with Article 2022 of the Constitution, which provides that county governments shall be allocated not less than 15% of registration to at least 35% within the first year of assumption of office. I think this has been talked about many times. We just want a specific commitment by our candidates that once they assume office, they are going to immediately increase the resources to the counties from 15% to 35%. We further proposed to create an intergovernmental trade committee. The presidential aspirants who assumes office should empower micro and small enterprises by giving them a 7 youth in the county human resources to provide for more inter-county transfers and everything treatment of the public sector workers within the counties. We therefore propose that a joint county public service board be established for all the counties to harmonize inter-county staff transfers and to deal with the common issues which arise between county governments as employers, taking policy areas, what we are calling the reducible devolution minimum, to ensure that devolution is protected and the people of Kenya are protected. Implementation committee to present this 11-point agenda to all aspirants who endorse this agenda. And needless to say that we, as representatives of the county governments, have said we are going to support presidential candidates based on their level of support and their commitment to enhancing devolution in this country. So, we don't want to hide. We know all the presidential candidates are talking about they're going to uplift the poor. The only way to do it is through support for devolution. So it's on that basis that, as the leaders of the devolution family, we have decided to make it public that we shall only support those presidential candidates who also support devolution. We call it the slogan, Imaliza Ugatuzi Yenga Inchi. We want to thank you very much. Stop there and request any members of this forum to say whether they are happy with it before we hand it over to the first presidential aspirant who is here with us, Honorable Justin Muturi. So, could I have some comments? Sorry, give us. Do you have another mic? You can give your name so that you can get to know who is talking. Oh.
Hello? Can you hear me? Thank you very much, Your Excellency, Governor Kiraitu Murungi. My name is Richard Owade, Ambassador Owade. It's a great pleasure for me to welcome my very good friend, the Speaker of the National Assembly, and the draft communique that you have read, which I think really encompasses virtually everything we've talked about. I would only add one very small thing on the bit about strengthening institutions that support country. I think you listed some institutions. But I would add, among those institutions, a very important institution which I think has not worked well, and that is the summit, the meeting with the Deputy President and the 47 county governors, and of course together with other operative, other officers. I think I would want the candidate, the presidential candidate, to commit that it will make the summit work. Because if summit works and meets frequently, I think a lot of these things will be sorted out. So we can either add a paragraph on the summit or just include summit among the institutions that were listed there that we need to strengthen. I think that's the only small addition I would want to add. Thank you very much.
Thank you so much. Any other comments? Just raise your hand so that, yes, give him the mic. Give your name again.
Thank you all protocols observed. My name is Ken Chweya Onsembe, County Attorney from the great county of Kisii. On the issue of resources, we agreed that the function, resources follow the function. And we expanded by saying that those resources are not only financial resources, but also infrastructural resources. What is happening currently, the debate is on financial resources. But we expanded it and said that infrastructural resources should also follow. So I think we'll improve on that communicate to indicate that we are very keen on its financial resources. Thank you.
Thank you very much, Onsembe.
Thank you, Your Excellency. As Ethicon, I'm the County Attorney of the Oil County of Turkana. And I'm glad to be here. Just a quick comment. I would like us to also reflect and perhaps add on the issue of restructuring the national government. And I'm saying this because of the challenges I've seen on the ground, where you have the former provincial administrator doing from the grassroots, I'm talking about chiefs, DOs and all that, and again the county government administration almost doing the same thing. And therefore we have sort of duplication and wastage. So I would like the presidential candidates to commit to looking at the structures of governance so that then we remove duplication. The last one, health being a devolved function, and I think water to some extent. The presidential candidates should do something about particularly the health in terms of either that health commission to deal with staffing issues for health workers at the county level. Thank you.
To commission.
My name is Alexander Kemi from the county of Laikipia County. My view, or I like the point of having a secretary, a devolution secretary at the Treasury, but the question I feel that should be more answered is the question of liquidity. Because at the end of the day, the division of revenue allocation bill is prepared on prospective revenue. But when the actual revenue comes into or hits the Treasury account, then the decision of or the prioritization should be written policy that the money in the Treasury account or revenue collected should be divided pari passu, such that if we have 100 standing
agreements. Okay. These are lawyers. silence means consent. So I think we have captured those infrastructural resources that is sound, and also the restructuring of the national government. I think there was also a proposal to create the Ministry of Devolution and Constitutional Affairs, which will constantly focus and prioritize devolution issues. The issue of county staff and the power being suggested. So at this juncture, we are coming to an end to our 2-day deliberations of the county attorneys. We have briefed the speaker, about our meeting and our challenges. We have made our requests. There's a committee which is supposed to be constituted between the National Assembly and the Senate, which we have not received. So please, when you go back, fast track it for us. We have a very short financial year. Whatever we have not done by March, we are not going to do. So if we can get that out of the way, we shall really appreciate. So without much ado, allow me to request you now to be upstanding. And you have to give a very mighty applause to the Speaker, the party leader, and the presidential candidate to come and officially close our conference today. 1, 2, 3. Karibu, Bwana Speaker, party leader, presidential candidate. Thank you very much. You're most welcome. Thank you.
Thank you. Be seated, please. Governors and the Governor of Meru, in this forum, Mheshimiwa Dewa Ome, ladies and gentlemen, it's indeed a pleasure for me and an honor to join you here in Meru to make these closing remarks at this consultative meeting of the county attorneys, which has been going on here for the last 2 days. I've had a chance to discuss key issues affecting county governments in the legal sector, and I note that the theme also is quite apt, defining the devolution agenda 2022 and beyond. In the workshop, as it is geared towards strengthening devolution, which is one of the key pillars, is a medium through which we can promote the social and economic development of all the 47 counties by ensuring the equitable sharing of national and local resources to all the corners of our republic. At all times, we must therefore always look for ways of making devolution work better in terms of achieving the objects of devolution as espoused in Article 174 of the Constitution. Ladies and gentlemen, indeed, this being an election year, I'm aware that many of you are certainly engaged in the campaign trails, creating time to deliberate on setting the agenda for devolution for this year and beyond, and undoubtedly it tells of your commitment towards strengthening devolution. On a lighter note, when our host, His Excellency Honorable Kiraitu Murungi, was a senator in the 11th Parliament, it is saying that in the year 2017, when he was vying to be governor of Meru, he never attended any conference or meetings, and the farthest you could find him was always within the precincts of Meru County in the campaign trails. that today, in an election year, he is here with us to the end is quite laudable also. I've also heard that this year, several second-term governors are going to vie for positions in either the National Assembly or the Senate. There is certainly need for champions of devolution to be in Parliament, and I wholly welcome that possibility of those that have served their 2 terms joining either the National Assembly or the Senate as champions of devolution. You may also agree with me that the devolution journey has been one of great achievements, and a visit to many counties can attest to this. However, the journey has not been devoid of various experiences that I choose not to call challenges, as we can learn from the experiences in I'm aware that during the consultative meeting, you've shared a lot of the experiences, but allow me to highlight 5 key issues based on the experiences of the 11th and the 12th Parliament on matters touching on devolution, which in my view may be used to define the devolution agenda for 2022 and beyond. The role of Parliament in strengthening devolution through legislation. Article 109 of the Constitution, which defines the legislative authority of Parliament, confers upon the National Assembly with the legislative role of originating and passing any bills. This broad jurisdiction means that the National Assembly considers all laws, including legislation which concerns county governments. Whereas ordinarily the Senate has been seen as the only house that considers laws that affect county governments, the Constitution made it clear that both houses can consider bills concerning county governments. And indeed, the truth, which I have had occasion to discuss with several people in the past, is that there's not any single law that is passed. In this regard, the Council of Governors should consider moving forward to engage in advancing its legislative agenda on bills that may require to be enacted to strengthen devolution. And again here, I wish to point out, because the Honorable JB Muturi has been in Bunge very many years. Knowing the challenges that our Senate faces for at least a majority of the senators being present, those elected from the 47 counties to vote, we find that in the National Assembly, we don't have any such challenge. And that's why bills moved in the National Assembly move much faster than those that emanate from the counterpart house. From my experience, the Council of Governors has sent minimal engagement with the National Assembly on its legislative agenda and considered by both houses in accordance with Articles 109 to 1 clause 3 will determine whether it is a bill concerning counties, and if it is, whether it's a special or an ordinary bill. There have been various interpretations in the past. The earliest one on this particular topic was by Justice Lenaola when he was in the High Court. Subsequently, he got, there was another one by Justice Macau and Justice Mumbi Ngugi. So that issue has always been problematic because in their opinion, in those provisions that touch on county governments, the failure to consult by the Court of Appeal. But we are saying that there is no reason in the national government. Yet none of them have any revenue-raising measures. So indeed, the National Assembly actually fights the war for the national treasury or the national government, which is not its function. You have no business. There's no business. But I also hold the view that the decisions made at the IBEC should be honored to the letter by the National Treasury while preparing the Division of Revenue Bill. So that it should never be an issue if the IBEC is chaired by the Deputy President, attended by, comprised of the 47 county governors, the 47 CECs in charge of finance, the Commission on Revenue Allocation is present in that meeting, the Controller of Budget is present at that meeting. Surely, the decisions taken at that meeting, and is a body recognized in law. The decisions taken there must not be tinkered with by either the National Treasury or even the National Assembly. I mean, so and for me, that would actually solve this problem of wars between the two houses about how much should go to the county governments. Further, as you may be aware, following the advisory opinion of the Supreme Court, and in keeping with the commitment to strengthening devolution, the National Assembly went ahead to amend the Public Finance Management Act of 2012 to entrench this unlocking device in law. I'm sure all of you are aware that following that advisory from the Supreme Court, that should there be a disagreement between the National Assembly and the Senate, as happened in 2019, the counties must not suffer, and that therefore the mechanism should be the shareable revenue that had been allocated to the counties the previous year should be used to do something which I'm sure the Honorable Creator knows very well, used to be there in the former constitutional dispensation, do something called vote on account, at which 50% of what had been allocated in the previous year will go straight to the counties, leaving now the two houses, if they must continue arguing, to argue, but the counties not be made to suffer, as happened in 2019. However, it is my submission that it is only through consultations that we can safeguard the functionality of county governments, and an unlocking device should be rarely used, as it is clear evidence of lack of consensus, cooperation, consultation, and commitment to strengthening devolution and making it work. Most countries, it is a fact, largely rely on the equitable share of revenue to provide services to the people, as there are limited sources of revenue emanating from the taxation at the county level, noting the narrow scope of the taxes that a county can impose in terms of Article 209, Clause 3 of the Constitution. This is perhaps the reason why the drafters of the Constitution sought to safeguard the functionality of county governments through Article 219 of the Constitution, which provides that the equitable share of revenue is to be transferred to the counties without undue delay and without deduction. Timeliness in releasing county funds is hence key for the efficient operation of the counties. And this can be achieved easily by the budget-making cycle, which is predictable in terms of the timelines. As the National Assembly, we are now finalizing on the budget policy statement for this year, and we intend to conclude on the budget cycle process early enough, including passing all the relevant financial legislations due to the elections. This has happened in 2017. Notwithstanding the requirement in Article 218 that Cabinet Secretary shall table the Division of Revenue Bill and the County Allocation of Revenue Bill before 30th of April of each year. As happened in 2017, this year we also intend to clear that much earlier. My hope is, why can't it be, especially when it comes to the issue of Division of Revenue and County Allocation of Revenue, why can't we assume that every year is an election year, so as to avoid this thing of delaying release of funds to the counties? Because this problem, obviously, as you may well appreciate, lies elsewhere, not with the houses. And indeed, the Honorable Kiraito in the communique is read out as alluded to that. But except that I feel that when there are too many demands, you set yourself for failure, because people are aware of accepting everything when they intend to do nothing. You may very well recall that I did say that we have a culture of political bad manners in this country. We are too quick to agree to do this or the other, but when it comes to implementation, we are very, very poor. I think, I hope if there's a mechanism that can be imposed that will compel everybody to accept to doing this. Let me turn to the second point of the third law of Parliament and strengthening devolution through oversight. And here I have three subtitles. One is the delimiting role of Senate. And the point I want to note here is that, as you are aware, Article 96, Clause 1 of the Constitution says that the Senate represents the people and serves to protect the interests of county governments. And therefore, if you add that to what is in Clause 3, that the Senate determines the allocation of national revenue among counties and exercises oversight over national revenue allocated to county governments. It's notable that a close reading of Article 96, Clause 3 of the Constitution reveals that the oversight role of the Senate is limited to exercising it of an only national revenue allocated to the county governments. And this obviously means that the watchdog committee of the Senate, being the County Public Accounts and Investments Committee, can only summon county governors to answer to audit queries relating to the funds allocated through the County Allocation of Revenue Act. Any money raised by the counties through collection of revenues from various taxes does not, in my view, fall under the purview of Article 96, Clause 3 of the Constitution, as these are funds which are not allocated in the counties from nationally. Moving forward, there should be an area that may require to be clarified in legislation to avoid unnecessary conflicts between the Senate and the Council of Governors, as has happened in the past. Number two is to look at how to strengthen the role of the Senate. Here, I wish to point out that as the chairman of the Parliamentary Service Commission, one of the strategic pillars of the Commission is effective representation, legislation, and oversight, which one of its objectives is founded on the need to strengthen devolution and the capacity of devolved units. The Commission is obligated to provide capacity building for county offices and county governments to enhance service delivery. There is, however, a need to include functional monitoring and evaluation structures for the oversight role of the Senate and develop and formulate linkages between the Senate and the county governments. You'll agree with me that an effective Senate that is able to represent the counties and serve to protect the interests of the county governments would assist in the realization of the objects of devolution as provided for in Article 174. C. The general oversight role of the committees of Parliament. The committees of the National Assembly and the Senate form the engine through which Parliament exercises oversight. The county governments have always raised issues relating to the interference of their functions by the constitutional commissions and independent bodies, which include the Salaries and Remuneration Commission in relation to the determination of remuneration of the members of county assemblies and the executives, and the Commission on Revenue Allocation in relation to its role in making recommendations on the equitable share of revenue. The Auditor General in relation to audit queries on county funds and pending bills, and the control of budget in relation to county budgets and withdrawal approvals. In the National Assembly, the constitutional commissions and the independent offices are oversighted by the Committee on Finance and National Planning, but I can confirm that the Council of Governors has never engaged the committee in seeking to resolve the issues they may have of alleged interferences in the performance of their functions by the constitutional commissions and independent offices. It is my suggestion that counties should engage with the National Assembly and the Senate committees on any matter under the assigned mandates for resolution. This is indeed in the spirit of Article 6 of the Constitution, that question of consultation and cooperation. I would also turn to the strengthening of the roles of the county assemblies. The county assemblies play a very critical role in oversighting the county executives, and whereas we have not witnessed over the years a rosy relationship between the county executives and the assemblies, you may agree with me that effective county assemblies would also facilitate the full realization of the objects of devolution. If county assemblies, through their committees, would, for instance, exercise their oversight role well, the governors who we are seeing being summoned by the Senate would not need to be summoned to answer to audit queries. As strong county oversight mechanisms would act as a filter and foster financial responsibility and accountability. Moving ahead, there is need for county assemblies to establish effective watchdog committees, as this would strengthen devolution. It is also my submission that separation of powers between the county executives and the assemblies, as a constitutional principle, can also operate within the parameters of consultation and cooperation. In 2013, when devolution was at the teething stage, you may recall that the Supreme Court issued an advisory opinion, reference number 2 of that year, which was a dispute filed by the Senate with the National Assembly, listed as a respondent challenging the manner of processing the Division of Revenue Bill in light of Article 95, Clause 4, Paragraph A of the Constitution, which provides that the National Assembly determines the allocation of national revenue. This matter was, after a long protracted dispute, settled by the Supreme Court. Further, several pieces of legislation touching on the functions of the county governments were also subject to challenge in the High Court. In 2019, the Council of Governors and the 47 counties also filed an advisory opinion at the Supreme Court challenging, among other things, whether an appropriation act can be enacted before the Division of Revenue Bill, what happens where there is an impasse with the passage of the Division of Revenue Bill and the County Allocation of Revenue Bill. the Supreme Court made a finding on all these issues for determination, and it is quite clear from the few cases that I have highlighted that court processes can threaten devolution. Why do I say so? It's because this can only be answered by examining the question of who loses where there are court cases. Are there winners in court cases? And in my view, there is none. Where 23 acts of parliament are nullified, as was the case in the High Court decision that I referred to earlier, and most of the acts were dealing with matters concerning county governments, it is the Senate, is it the Senate that won? Where no bill can be considered in the National Assembly due to orders of a court, like happened in that matter, who loses? Is it the National Assembly? Definitely not. It is devolution that loses. It is the people you represent who lose. When the Supreme Court, for instance, takes time to determine the issues filed by the Council of Governors relating to financial legislation, and an impasse is expected to be unlocked through the court processes, who's the loser? Is it the Council? Does the Council of Governors win? There are no winners in adversarial court processes. It is devolution that loses. It is the people who lose. To this end, the two houses of Parliament and the Council of Governors should aspire to employ alternative dispute resolution mechanisms in resolving disputes between the national government and the county governments. Undoubtedly, the drafters of the Constitution and envisaged this and provided in Article 6 about consultation and cooperation of both levels of government. As I conclude, I could go on and on and on, but let me recognize that we are gladly on a journey of achieving the objects of devolution. We can learn from our experiences and improve on the journey. We've had a decade of devolution, and what I find all over is success, and therefore we should build on this. I believe that much lies ahead in terms of the agenda, and the counties that are beyond the elections for this year. For me, the beginning point is strengthening the consultation and cooperation mechanism between Parliament and the county governments in legislation and oversight matters, and the national government and the county governments. If this is done, all that shall be left now will be to ensure that county governments have adequate funds to perform their respective functions conferred under Part 2 of the 4th Schedule to the Constitution. For instance, all the funds allocated to the national government on matters agriculture, and this has been my pet subject, should be allocated to counties, as the only role of the national government in relation to matters agriculture is agricultural policy. The same delineation can be ticked for all the 14 functions and money allocated in the counties to strictly follow the respective functions. Indeed, in your communique, you have made reference to matters health. I fully agree. There is also need for the county government to put in place structures that can harness revenue collection through use of technology so that they can boost their own source revenues beyond the annual county allocations. Lastly, in 2022 and beyond, we look forward to counties that shall prioritize the implementation of development projects of a recurrent expenditure and explore mechanisms through which the pending bills can be settled through assistance from the national government. That is our wish list for you. And more specifically, even as much as we talk about assistance, the national government still retains a lot of money that is meant to be at the counties. Indeed, I agree, as you said in the communique, if you consider what was provided for in the Abuja Declaration on matters agriculture, matters health, what we are doing is a shame in the country. If we are serious, and indeed everybody agrees that devolution is the greatest achievement that we got in our Constitution 2010, then we must go beyond mere platitudes. Your Excellency, Governor Kiraitu, in conclusion, let this be the legacy that we leave for our country. Let us not be remembered for the positions we held. We should be remembered for having promoted the social and economic development of the counties and ensured that all counties from Garissa to Mombasa, from Meru to Busia, and from Kisumu to Turkana have experienced this development in reality. This should be our legacy, and the people of this great nation are looking up to us. Now that the elections are around the corner, allow me to leave you with the words of the 8th President of the United States of America, Martin Van Buren, who served between 1837 and 1841 for only one term. I quote, "As for the presidency, the two happiest days of my life were those of my entrance upon the office and my surrender of it." Close the quote. The people at our system, like the king in a monarchy, never die. It is easier to do a job right than to explain why you did not. Your Excellency, let the people you serve remember you for doing the right things, which is that you strengthened devolution. And indeed, as the county attorneys, please be remembered for the same. I wish to thank all of you for participating in this noble workshop and for sharing valuable experiences and contributions, which is my hope that from here we shall proceed to implement. Since the communique was read in my presence, let me say that I will study it carefully. It's only fair, you cannot just append your signatures on documents. In this country that we've had people complain that in 2002, in the euphoria that was there, certain documents were signed, certain promises made, and the rest, I'm sure, is history. It has always continued to be. So I hope the Council of Governors will not just require of us to come before you and sign documents, after which later, if people are sent to offices, they start raising technical issues that, you see, the Constitution does not permit me to do this. Because then, if they rely on the Constitution and they have already assumed office, there may be no enforcement mechanism. Thank you very much for listening to me while making these my official remarks. I've been asked to state someone like I officially declare the workshop closed. Thank you very much.